Today I'm going to be talking about the King County case schedule. If you are a civil litigant in King County Superior Court in Washington State, then more likely than not, your case is going to be governed by this case schedule. The case schedule was auto-generated when the lawsuit was filed, and it is something that both the plaintiff and the defendant must follow. So I'm going to go through some of the specifics of this document, but your case schedule for your case will have dates filled in over here on the right-hand side. So the first thing you'll see is the date that your case was filed. And you'll notice when you look at the trial date that the trial date is just about a year from the time the case was filed. Now, a year may seem like a long time, but trust me, this goes fast. And all of these things have to be done before the trial date. So let's go through some of the things that need to be filed with the court. So the first major pleading with the court that at least is on the court schedule is the filing of the statement of arbitrability and the filing of the confirmation of joinder. You're going to see the dates are the same for each. That's because you only file one or the other of these two documents. If your case is subject to arbitration, then you'll file the statement of arbitrability. If your case is not subject to arbitration, you'll file the confirmation of joinder. See, if right here it says if not subject to arbitration. Now, one of the things that is a little bit difficult about this is that I'm posting this video in late August 2018. As of September 1st, the limits for what can be arbitrated are changing, and whether that change will take place in King County specifically is still a little bit up in the air. So you'll just want to be sure that you have a clear understanding of what the limits for arbitration are before you figure out whether you need to file the statement of arbitrability or the confirmation of joinder. Now, either way, these documents right here are filed by the plaintiff, typically speaking, okay? So the defendant doesn't really need to worry about either of these two documents as a general rule of thumb. Circumstances may come up where they need to. The statement of arbitrability simply tells the court, hey, we're ready to go to arbitration. We can be taken off your radar for all of these deadlines here, and it requires an extra $220 fee. The confirmation of joinder tells the court that the defendant or defendants have answered the complaint and parties are gearing up for litigation and to keep this trial date on the calendar, and that you can expect that all of these deadlines will be complied with. So this is a good 4 months or so after the case is filed. So during that time, presumably other things will be going on behind the scenes that may not be actual filings with the court according to the case schedule. So the next thing that you'll find on the case schedule is the deadline for hearing motions to change the case assignment area. We have two courts in Superior Court in King County. One is in Kent, the other is in Seattle. If a party wants to change the courthouse within King County, then this is the deadline for doing so. I've been practicing about 13 years now, and I have never seen a motion to change the case assignment area. Just one of those motions that I don't think gets filed very frequently. So then about 4 or 5 months now, we're looking at the disclosure of possible primary witnesses. These are documents that are exchanged with the other party. Both the plaintiff and the defendant must serve this document on the other side if they're not in arbitration. Now, this disclosure should name all of the witnesses that the party knows of, even if they don't know for sure whether they're going to call them as a witness at trial. This disclosure of possible primary witnesses is not filed with the court. The next thing that is filed, which is just about a month and a half after the disclosure of possible primary witnesses is the disclosure of possible additional witnesses. Again, this document is exchanged with the other side. It is not filed with the court, and additional witnesses might be those witnesses that you've recently learned of. Maybe it's a rebuttal witness in response to the primary witnesses named by the other party. Maybe it's a new expert witness. Although it's more important than not to name your experts in the primary witness statement as long as you're able to do so. So from there, after the disclosures of witnesses, you have a deadline for a jury demand and a deadline for a change in trial date, and these two dates are the same. Either party can file a jury demand, and either party can file a motion to change the trial date. So sometimes cases move at the wrong speed. Maybe they're taking a little bit longer than thought. So if the trial date needs to be changed, it's really important to get that in front of the judge before this deadline, because judges don't like to extend the trial dates if they can be avoided, and bringing that motion after this date is somewhat difficult, if not really difficult, depending on who your judge is. Same with the jury demand. You don't want to blow this deadline. Otherwise, you may have waived your right to have a jury. So then, after the deadlines for the jury demand and the change in the trial date, then you have your deadline for discovery cutoff, the discovery cutoff. Now, this is the deadline when all of the discovery is supposed to be done. The parties can agree to extend that if they want to, but I'll tell you that it makes it very difficult to prepare for trial if you're finishing discovery. And that's why your discovery cutoff is about a month and a half, 6 weeks in before your trial date, to give you time to prepare for trial. So the discovery cutoff, the types of discovery that can be conducted are in one of my blog posts, and I will post a link to that in the comments below. So then after discovery is completed, the courts really want the parties to engage in some sort of mediation or alternative dispute resolution to try and resolve the case. Because once the parties start doing all this trial preparation, it's going to be very difficult to resolve the case. And it's important from the perspective of court congestion to really try and encourage the parties to settle as opposed to going to trial. Trial is very uncertain, and there are a lot of contingencies in there. So this deadline is simply the deadline whereby the court wants the parties to have tried to resolve the case by more formal methods than just emails or phone conversations. So from there, the rest of the deadlines in here are all trial preparation documents. Before trial, we don't have trial by ambush. So if you think about it, these disclosures of witnesses advise the other side of who the key witnesses are. The discovery that can be conducted allows parties to access information. And so now it's time, when you're down in this part of the case schedule, to really drill down who's going to be called at trial, what documents are going to be called at trial. So to do that, you have to exchange lists. You have to let the court know that you're ready for trial. And you have to file a joint statement of evidence so that issues where the parties have agreed, the court can know that, so they don't have to deal with issues that really are not in dispute. There's one deadline here that is actually really important, and it's really complicated, and I don't think I'm going to be able to get to it in this video. But this is the deadline here for hearing motions for summary judgment. And motions for summary judgment can be brought any time prior to this date, but they're complicated motions. They're generally motions where the court has to make a decision of law. And so this deadline here is not technically a pretrial deadline, but it is a substantive motion deadline. So here, near the end, you still have other documents that need to be filed. And this is immediately, really, before trial. You have your trial briefs advising the court what the case is about. If you're having a bench trial, you have to prepare documents for the judge. If you're having a jury trial, you have to prepare jury instructions. So that then will bring you to your trial date. So all in all, this case schedule provides such a nice roadmap for the parties to follow. I did want to again mention that if you're in arbitration, as opposed to going forward with litigation here, these deadlines are off the calendar. But as long as you're not in arbitration, you have to comply with all these deadlines. It sets the expectations for the parties and really allows for an orderly way of litigating a case. So please feel free to contact me with any questions. I know this was kind of a crash course. Hopefully you'll have a better understanding of what the case schedule is and why the court issues these deadlines next time you're looking at your case schedule or talking to your attorney about what all these deadlines mean. So thanks so much for watching.